supervision with your attorney. Did you understand it?
Yes.
Let's roll. Nerds is wild for a courtroom start, but don't let the casual tone fool you. This is a high-stakes probation revocation hearing tied to deferred adjudication, which means the defendant was originally given a chance to avoid a conviction, but only if he followed strict conditions. And in cases like this, the rules around internet access and treatment compliance aren't minor details. They're central safety conditions, especially when we're dealing with a sex offender treatment program. What you're about to watch is the system's second chance getting tested. The defendant pleads true to multiple violations: internet identifiers on social platforms, accessing unmonitored devices, and being terminated from treatment for failing to progress. The judge is going to spell out the maximum exposure, up to 20 years, because that's what happens when deferred adjudication gets revoked and guilt is adjudicated. The big suspense here isn't whether violations happened. It's whether the judge accepts the negotiated deal and how the victim's age and safety conditions shape what happens next.
Are you the same Angel Antonio Cantu who's placed on deferred adjudication in 20 or on August 25th, 2022 for a period of 10 years? Is that you?
Yes.
State.
Yes, Your Honor. Violation condition number 13A. On or about the 11th day of September 2025 in Bexar County, Texas, the defendant, Angel Antonio Cantu, did then and there fail to comply with the instructions of the Bexar County Community Supervision and Corrections Department, and that the defendant admitted to having internet identifiers on Discord, Kick, and other social media platforms. Violation condition number 13.
How do you plead to that? True or not true?
Sure. Violation condition number 13B. On or about the 16th day of September 2025 in Bexar County, Texas, the defendant, Angel Antonio Cantu, failed to comply with the instructions of Lone Star Offender Treatment Program, his court, in that the defendant failed to progress toward reasonable treatment goals and was terminated from treatment in violation condition number 13B.
How do you plead to that? True or not true?
Sure. Violation condition number 13JA. On or about the 11th day of September 2025 in Bexar County, Texas, the defendant, Angel Antonio Cantu, did then and there failed to comply with the instructions of the Bexar County Community Supervision and Corrections Department, and that the defendant admitted to accessing the internet on an unmonitored device in violation of condition number 13JA.
How do you plead to that? True or not true?
True. Violation condition number 13L. On or about the 11th day of...
Let me just stop you all. Are you all doing 13L but not 13F?
13F and 19 are going to be waived by the state.
Okay. Do you really need 13L?
You can waive 13L as well.
No objection, Judge.
All right. Did you understand by pleading true to 13A, 13B, 13JA, the court could find it true, grant promotion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to 13A, 13B, and 13JF?
Yes, Your Honor.
Court will find 13A, 13B, and
This is the
13J.
part a lot of viewers misunderstand. When the defendant pleads true to violations, it's basically handing the court proof without a contested fight. The judge doesn't have to guess. The defendant is admitting noncompliance. And look at what the violations are: multiple internet identifiers across platforms and accessing the internet on an unmonitored device, plus termination from the treatment program for not progressing. In supervision cases, that combination is serious because monitoring and treatment are the two pillars the court relies on to reduce risk. Also notice the judge's warning. Pleading true means the court can revoke, adjudicate guilt, and sentence up to 20 years with a fine. That's not intimidation. That's legally required clarity. The court is making sure he understands the consequences before accepting the plea. Question for you. Once someone admits these kinds of violations, should the court still prioritize rehabilitation, or is prison the inevitable outcome? This is the part a lot of viewers misunderstand. When the defendant pleads true to violations, it's basically handing the court proof without a contested fight. The judge doesn't have to guess. The defendant is admitting noncompliance. And look at what the violations are: multiple internet identifiers across platforms and accessing the internet on an unmonitored device, plus termination from the treatment program for not progressing. In supervision cases, that combination is serious because monitoring and treatment are the two pillars the court relies on to reduce risk. Also notice the judge's warning. Pleading true means the court can revoke, adjudicate guilt, and sentence up to 20 years with a fine. That's not intimidation. That's legally required clarity. The court is making sure he understands the consequences before accepting the plea. Question for you. Once someone admits these kinds of violations, should the court still prioritize rehabilitation, or is prison the inevitable
B
outcome?
and 13JF true? Is there a proposed agreement?
There is, Your Honor. That is to grant the state's motion, revoke the defendant's probation, adjudicate and sentence the defendant to 8 years in prison.
All right. Why should I follow this?
So Judge, Mr. Cantu so these allegations arrive from Mr. Cantu's own statement. So he was self-disclosing of these things during the process of which he was getting treatment for under the sex offenders program. He had been asked by his counselor, through the various ways they go through counseling, how are you doing? What's going on? He self-reported these incidences. The thing that
Defense
What I
counsel is leaning hard into one mitigating point: self-disclosure. They're saying these violations came from the defendant reporting his own conduct during treatment, meaning he wasn't caught through an investigation. He admitted it. That can matter because it signals some level of honesty or engagement, even if it's late and imperfect. But the flip side is brutal. Self-reporting doesn't erase the violation. It confirms it. And if treatment terminated him for failure to progress, that tells the court the rehab track wasn't working under current conditions. Then comes the moment that instantly tightens the room: the complainant's age. When the judge asks and the answer is 11, with clarification 14 at the time, it frames everything. In sex offense-related supervision, victim age heavily influences restrictions, risk evaluation, and sentencing seriousness. That's why you immediately hear the judge say, "I remember this case now." Once that recognition hits, accepting the agreement becomes less about sympathy and more about whether the proposed time and conditions protect the public.
What I understand from how I've looked at this case is that my client has had struggles with doing probation. I think ultimately probation is good because it helps us find these issues where we have problems that kind of relapse up. I think given that Mr. Cantu has indicated, we're here today because he's not hiding anything. He's not proud of what he did, and he has indicated to me that he understands that this is, it's not good, and he shouldn't have been doing it in the first place, Judge.
So has he had contact with the complainant?
Judge, it is my understanding that he has not. I do have the mother of the complainant here is present, if you would like us to call her, Judge.
Well, you talked to her. She's saying that he hasn't had contact?
That is what she said, Judge, and I understand that's only her statement.
All right. And how old is the complainant?
I'm going to give her
How old is the complainant?
My mother. 14, Your Honor.
Okay.
Judge, 14 at the time of the top.
Yes.
Oh, okay. I do remember this case now. And I'm sorry, could I have the trial court certification? All right. And I'm sorry, State, why should I follow your agreement?
in the contention of justice with this coming about fair prison sentence from the state point of view.
I'm sorry?
It's a fair prison sentence from the state point of view.
So what has he done on probation?
I'm sorry, his probation officer was here a little bit earlier.
Okay.
But according to the court summary, there has been 3 negative UAs. He was in treatment, but there was some issues there. As far as anything else, he was on the so moved caseload, but there's a total credit of $1,163 toward his supervision fees. But other than that, Judge, nothing.
Here's the final outcome. The judge follows the plea bargain, revokes supervision, adjudicates guilt, and sentences the defendant to 8 years in prison. The court also imposes strict safety conditions, no contact with the complainant, and requirements tied to registration and restrictions going forward. And then the judge locks in the procedural finality. Because this is a plea bargain and the defendant waived the right to appeal, the court makes it clear there's no permission to appeal the sentence. That's why the judge takes the trial court certification seriously. It documents that the defendant understood what rights were given up. Finally, the judge adds a common felony consequence: no owning or possessing weapons or ammunition, with a reminder to consult an attorney for specifics. Clean, direct, and final. This is the system closing the second chance chapter and moving into punishment and protection. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will revoke, find you guilty, sentence you to 8 years in the prison. There's to be no contact with the complainant, no residing in, no contact with, and Chapter 62 registration. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement? I'm sorry, I need that back. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Could I have his file back, please? Yes, ma'am. With the trial court certification.
Yeah.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
John.
All right, good luck to you.
Thank you, Your Honor.
Okay. All right, who else has a contested hearing with witnesses?
Mine is separate contested, but we spoke yesterday
Yes.
about getting.
Who's your client?
His name is Alon.